Let's go to Peter Landers now to talk a little bit more about this decision and just what this means for companies that oftentimes are just looking to patent everything and anything. Peter, good morning.
Good morning. You're exactly right about companies. I mean, in recent years, you've seen all kinds of things, both in the tech industry, the medical industry, get patented, and often the Supreme Court has had to step in and rein in some of these patents that they call excessive.
Now, Peter, it can't be that often you get a Supreme Court ruling that quotes Archimedes and the laws of buoyancy, like this particular Supreme Court case. So, what does the Supreme Court? What do they have against this particular type of medical diagnostic testing?
Oh, I thought you were going to say, was this court have against Archimedes?
Against buoyancy, okay, actually, about boat building.
Sorry, Peter, don't worry about Archimedes.
I mean, the court says it's wonderful if Archimedes has a eureka moment in his bathtub and discovers the law of nature. The problem is that he cannot patent that law of nature, nor can he patent some sort of method or instruction set to a company on how to build a boat that floats and doesn't sink if the instructions are merely telling that company to apply the law of nature in a very obvious way. So you have to have some inventive concept that goes beyond the law of nature and is not obvious.
And so what in particular was this medical diagnostic test that Prometheus tried to patent? What was it supposed to do, and what was their argument for it deserving a patent?
Right, this is a test for people with the Crohn's disease to test whether they're taking too much or not enough of a particular drug that is used to treat Crohn's disease and other disorders like that. And the test basically draws on, as the Supreme Court says, the law of nature, that if you have certain chemicals in your blood, it shows you're taking too much or too little of the drug. And the company is saying, we've applied that law of nature. We've given doctors some very useful instructions that were not obvious on how to apply that and turn it into a diagnostic test that will be useful to Crohn's patients. And what the court is saying is, your steps are obvious. Anyone who knew the law of nature could instantly use those steps to treat a Crohn's patient, and it's not patentable.
All right, Peter, one thing with this is it seems like this decision was a bit of a surprise, especially because it overturned a ruling by an appellate court, and the medical companies were saying this would stifle innovation. You even had the Obama administration seemed to be on the side of the drug companies.
That's right. I mean, it did come as something of a surprise, especially if you look at the 9-0 ruling. It was a unanimous ruling, and the Obama administration had mostly sided with the companies, and they're warning, as you say, that this will hurt the innovative drive of medical companies. They will find it harder to patent these tests in the future.
What does pulling back from the medical companies or the medical industry, where does this signal the court is going more broadly in terms of patents?
There are a number of decisions in recent years that tend to, although not always, but tend to rein in, as I said, the Federal Circuit, the U.S. Court of Appeals for the Federal Circuit, which is a specialized court that hears patent cases. And this court has tended to be pretty generous to companies, especially on this law of nature question. And so there have been a number of decisions where the court reins in the Federal Circuit and says, no, that's not patentable.